Harvard Law professor emeritus Alan Dershowitz. Professor Dershowitz is no stranger to high-profile cases. He was part of O.J. Simpson's dream team of attorneys during O.J. Simpson's criminal trial. Professor Dershowitz handled the potential appellate issues in the case. He also represented former President Donald Trump during his first impeachment trial, and he also represented a kidnapping victim, Patty Hearst. These are just a few cases that he's been involved with. And the professor also has a brand new book out today. It's called The Case Against the New Censorship: Protecting Free Speech from Big Tech, Progressives, and Universities. Professor Dershowitz, a big welcome to you. Thank you so much for joining me.
Well, thank you. You know, I rarely make predictions, but I'm going to make a prediction now, and I know it will be shown again in a year or a year and a half when I claim my prediction will come true. I predict the United States Supreme Court will reverse this conviction, will certainly take seriously the reversal of this conviction, and ironically, it will base the reversal on cases growing out of Ku Klux Klan, when in the 1920s and the 1930s and the first decade of the 20th century, political leaders, much like Maxine Waters, of course, on the other side, and much less credible and having much less of a moral claim, but political leaders led protests outside of courtrooms that had racially charged trials, and they influenced juries, and they made threats, basically. If the jury were to acquit an African-American man or convict a white man, there would be repercussions. And courts, including the Supreme Court, have reversed convictions based on that. And I think what Maxine Waters did and said, coupled with what others said before that, and coupled with the judge's refusal to sequester the jury from the beginning, and his weak instruction just not to listen to the news, I think will be enough to reverse any conviction in this case. The judges hinted at that. I think the judge is right, so stay tuned. This case will not end with this jury verdict. I don't think the Court of Appeals in Minnesota will have the courage to reverse this conviction based on these grounds, but I think the United States Supreme Court may well do that.
If they do, Professor, I'm curious to get your thoughts as to whether or not they may draw on another big case. I heard you mention it. It's a case I am fascinated with, the Shepard case. Do you think that case could be grounds, should this case go all the way up for appeal, that case all about the court's duty to protect a defendant's right to a fair trial and insulate them from the media exposure?
Right. Mm-hmm. And it was litigated by my friend and colleague, Effley Bailey, who was my co-counsel in the O.J. Simpson case. But there were many other cases as well, cases involving racial issues in the South, where jurors clearly were threatened, where the sword of Damocles hung over their head, where a message was being sent. Remember, when the Klan had these protests in front of the courthouse, they would have elected attorneys general, elected mayors, they would have ministers, they would have very prominent people being part of the threat. And what Maxine Waters did, although she's on the right side of the racial issue and the Klan was on the wrong side of the racial issue, in terms of the tactic, is right out of the playbook of the Ku Klux Klan. And that's what's so disturbing and ironic when you have a civil rights leader like Waters using the tactic of the Klan to try to influence the jury. And, the idea that she incited violence, that's secondary. The primary thing is she intended to have an influence on this jury's deliberations. She told them, we will not accept the manslaughter verdict. We want a murder conviction. And if you come back with a manslaughter conviction, we will be confrontational and go to the streets. I do think personally, having seen the entire trial and watched the evidence and looked at the evidence, that probably the justice verdict in this case, based on the evidence of the law, would be for manslaughter in the third degree and the second degree, but not murder in the second or third degree. But the jury may come back with murder or with manslaughter. But you have this threat. If you come back with manslaughter, if you look at the evidence and come to the conclusion that no, there wasn't felony murder under the second-degree murder, no, there were no threats to others under third-degree murder, and you come to your own conclusion based on justice, believing that manslaughter is the right verdict, there will be consequences to you, to your family, to your schools, to your businesses. Let's remember already, one of the witnesses in the case who testified for Chauvin had what was his former home, but they thought it was his home, covered with blood and other kinds of threats. The lawyers have received threats. Others have received threats. The air of violence is prominent, and the jury breathes that air. There is no way the jurors don't know about Maxine Waters' statement. There is no way they don't know about the statements of Sharpton and others. There's no way that the protests outside the courtroom have not gotten into the jury box. You know what defense lawyers say, when you throw a skunk in the jury box, you can get rid of the skunk, but you can't get rid of the smell. And the smell of violence is in that jury room now as the jury is deliberating.